Mike, I know that you were a cop for 13 years, and now you're a criminal defense lawyer. You're also the director of a drug treatment center, and really a statewide recognized expert on drug treatment and jail alternatives in drug cases. I want to ask you about Prop 36, because we get calls all the time from people who say, I was arrested, my family member was arrested, and I want to do Proposition 36. First of all, who qualifies? I mean, who was eligible to do that, to do the program?
Well, under Proposition 36, which is actually Penal Code Section 1210 here in California, basically if you're arrested for simple possession, felony simple possession, for example, you have a small amount of heroin or methamphetamine, which is typically what we see, at least in San Bernardino County and Riverside County. If you're arrested for those charges, you are technically eligible for diversion. And Prop 36 was the proposition passed, and it's enacted under the law, that provides rehabilitation and treatment. And the great thing about Prop 36, if you're eligible, if you get into the program, it's about an 18-month program. And you're constantly monitored. There's testing that goes on, and we tell clients all the time, be prepared to change your life if you have a drug problem, because the course will make you change your life to be successful. After successfully completing the program, the conviction is dismissed from your record like it never occurred.
You talk about doing a program. So is this an inpatient program where you live there, or do you just go in for classes? Can you work at the same time? How does it work?
Well, generally, the Prop 36 program is out of custody. You can work. There's classes. There's follow-up with the court. You're appearing before the court often. There's drug testing. There's a requirement for NA classes or AA classes, or both. And basically, the court will want to see your progress on a monthly basis. And if there's any violations, the court can take punitive action against you.
Now, speaking of violations, so my understanding, I want to do Prop 36. I go and I plead guilty, first of all, to the drug charge, right?
That's correct. You have to plead guilty at your initial appearance, or pretty close in time to your initial appearance.
And then sentencing is put over for a period of time.
It is.
And I do this class, correct?
You do.
And if I drop out of the class, if I pick up a new case, if I fall off of Prop 36 during that time, what can happen?
Well, it would be a violation of the terms of your Prop 36, and they could either, one, give you county jail time, two, they can send you to state prison. Now, one of the great things about Prop 36, you sort of get a couple bites of the apple, because they understand that people with dependency problems, relapse is part of recovery. I mean, that's a statement in the recovery community. Being the president of the board at Cedar House, which is a 125-bed outpatient and inpatient facility in Bloomington, I've learned that. I've learned that relapse is part of recovery, and the courts understand that. So let's say, for example, you're on felony probation, not Prop 36. You violate probation, you can go to prison, and oftentimes people do go to prison. Prop 36, if you fall off the wagon, if you relapse, they're going to give you a little jail time sometimes. They're going to increase the monitoring of you, make sure you meet that you meet what you need to meet. But they don't necessarily just throw you in jail or certainly throw you in prison.
But the judges have a lot of discretion, and they'll work with you.
They have great discretion. In fact, our judges locally that do drug court, that they do Prop 36 programs, they believe in the program, and they really want to see people succeed. And so they have to be able to use that broad discretion that they have in order to make people successful in the program, because relapse is part of recovery.
Let me ask you, you talked, Mike, about pleading guilty in order to do Proposition 36. What if I want to take my case to trial? Let's say I'm charged with possession of cocaine, and I don't think that they can prove the case. I don't think it was really mine. My position is it was someone else's drugs. Can I take my case to trial and try to get a not guilty verdict? And if I'm convicted, can I still do Proposition 36?
Very unlikely, and I'll tell you why. While it's technically possible, it's very unlikely, because the courts, when they offer Prop 36, or the DA offers Prop 36, the drug diversion program, there has to be a recognition that I have a problem. That's the whole part of the program, is I want help. And that's why when you do enter a plea and get in the Prop 36 program, when you successfully complete it, it's dismissed from your record. So it's sort of early resolution of cases. It's sort of an acknowledgement of, I have a problem, I'm looking for help. So it's a rare occasion. In fact, I can't recall off the top of my head at any time that I've had a case where a client went to trial, lost, and then was given Prop 36. And I don't even recall that ever happening in any of our local courts, as far as I can recall.
Let me ask you, you said that it's for simple possession, cases of just possession for personal use. What if I'm charged with, let's say, selling cocaine or possession for sale of methamphetamine? Does that make me ineligible for Proposition 36? And if that's the case, are there things that you can do to try to get me to be eligible anyhow?
Statutorily, if you're charged with transportation, possession for sale, or even maintaining a place where drugs are maintained, used, or sold, you are statutorily, under the code, ineligible for Proposition 36. You're ineligible for relief. We face that all the time. I mean, many times we'll start cases where they are charged with 11379, transportation or possession for sale, whether it's because of the amount or there's some scales involved or some baggies and things like that. Historically and very typically, if we can show the DA that the underlying problem is drug-related, that even if someone was having drugs for possession for sale, but it was to feed a drug problem, we've been very, very successful in having the DA agree to strike those allegations, strike those parts of the complaint, amend it to a simple possession, 11377 of the Health and Safety Code, and get these folks into a Prop 36 program. I'm Mike Scafidi, a retired police officer and now a criminal defense attorney with Schaus Law Group. If you or a loved one are in trouble and need help, call me.